and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, I now call to order this Brevard County Board of Zoning Adjustment meeting for December 2022. Our first order of business is ask if there's any staff announcements.
We don't have any staff announcements.
Okay. One of our longtime board members, a gentleman named Jack Higgins, was forced to resign for health reasons, personal reasons. And in his stead, we have Miss Chelsea Pattertridge as a stand-in, hopefully going forward as a permanently appointed member based on whether her commissioner in District 1 sees so fit to do. With that, we will have Mr. Bodie, could you read the definition of the function of the board?
Yes, Mr. Chairman. The Board of Adjustment is a quasi-judicial body established by the Board of County Commissioners under Chapter 62, Article 2, Division 4 of the Brevard County Code. The Board of Adjustment is empowered to hear requests for variances to the zoning regulation and the sign regulation in Chapter 62, Article 6, and Article 9. Pursuant to Florida Rules of Appellate Procedure, any person or persons jointly or severally aggrieved by any decision of the Board of Adjustment may, within 30 days after the date the order is signed, apply to a court of competent jurisdiction for appropriate relief. Mr. Chairman, you have 8 items on your agenda today.
Thank you, Mr. Bodie. Mr. Rhodes. Sorry, Dale. Mr. Rhodes, could you read the statutory definition of an undue hardship?
An undue hardship. A variance may be granted when it will not be contrary to the public interest and where, owing to special conditions, a literal enforcement of the provisions of this chapter will result in unnecessary and undue hardship. The term undue hardship has a specific legal definition in this context and essentially means that without the requested variance, the applicant will have no reasonable use of the subject property under existing development regulations. Personal medical reasons shall not be considered as grounds for establishing undue hardship, sufficient to qualify an applicant for a variance. Economic reasons may be considered only in instances where the landowner cannot yield a reasonable use and/or reasonable return under the existing land development regulations. The applicant must answer a variance hardship worksheet with 6 questions. The Board of Adjustments will discuss these questions today with each applicant who has requested a variance.
Okay. I would now like to address our audience, our board members and staff regarding the board procedures that we will be following today. The Board of Zoning Adjustment, as a quasi-judicial board with members appointed by the Brevard County Board of Commissioners, will utilize Robert's Rules of Order to conduct its proceedings. The chair is asking all board members not to ask questions while the applicants are making their initial presentations. Once the applicants have completed their presentations, we will begin board questioning with the board member whose district is board member who represents the applicant's district. When concluded, questioning is open to the full board. The chair will recognize each board member in turn. Once all board members have completed their questioning, we will then open the floor to the audience who may be here to speak concerning the applicant's application. Anyone from the audience wishing to speak will be given the opportunity to address the board that once. At the conclusion of public comment, the applicant will be given additional time for rebuttal, as well as to present their final comments. Once completed, no further comment will be heard from the applicant or the public. The action then moves to this side of the bar for board discussion. We will not use a timer for today's meeting. Instead, we are asking each speaker to be concise in what they have to say and stay on point. It is important that you stay on the subject and avoid information that is not relevant to your application. All persons speaking must provide their name and address for the public record. Those wishing not to verbally state their address may ask the clerk at the podium for an address card. Please fill it out and return to the clerk at that time. Next order of business for our board is approval of last month's meeting minutes. Any changes?
Mr. Chairman, I make a motion that we approve the minutes as written.
I'll second that.
A motion has been made by Mr. Rhodes, seconded by Mr. McCann to approve the meeting minutes. All in favor say aye.
Aye.
Any opposed? The meeting minutes are approved. Now, I would also, for reasons, ask for a motion to reverse the order of the first two items on our agenda.
I'll make a motion to swap the first two items on the agenda, H2 being first and H1 being second.
I'll second.
Any discussion? I will call the vote. All in favor, say aye.
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 All opposed? The motion passes.
Mr. Chairman?
Yes, sir.
If you don't mind, would you explain why we did that so that the people don't think there's a problem?
The reason we did that is we have our new board member, Ms. Partridge, and we would like to have an example proceeding on one application that she can get a sense of the flow of how that goes before we throw her right into the first one that she's going to be taking the lead on. So that's the explanation for that motion to reverse just the first two. So with that
Thank you, sir.
said, no, that's good comment. With that said, Mr. Bodie, may we have our, well, I guess it's our second applicant first.
Yes, David Mojica. Request variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-2100.51D to permit a variance of 1,350 square feet over the 600 square feet allowed for an accessory structure. Variance number 2, 743.3 square feet over the 1,519.1 square feet allowed for an accessory structure in RU-1-9 single-family residential zoning classification, and it's located in District 5.
Okay, thank you. Could you raise your right hand? Do you swear that first, state your name and address.
My name is David Mojica, and I live at 2180 Michigan Street, Melbourne, Florida, 32904.
Okay. There's a name on here, Matthew Slate.
Correct.
Is
That's my general contractor.
that, okay. Raise your right hand. Do you swear that the testimony you're going to give us today is the truth?
Yes.
Okay. How can we help you?
So requesting the variance for a large structure, the size of my house kind of limits me on the size of the structure based on the rule being on the percentage of the house. And being that I own like 9 to 12 cars, having them outside all the time it wears on them. And they're cars like 1956 Cadillacs and 65 Cadillacs and old 90s Z Camaros, and they start to deteriorate, and being in the weather all the time it wears hard on me trying to build them and maintain them at the same time. So the structure would be to store them and keep them from deteriorating, so the easier they are to get built. And that's like pretty much all I do all the time is I build my cars.
Okay. Your application rises in District 5, which I happen to represent. So I will begin the questioning. I'll give the floor to myself for that. I need to let you know that we have received a letter of opposition.
Correct.
Do you have a copy?
I did.
You do have a copy, okay. I did drive through your neighborhood, and I did not have my calibrated eyeballs on, but I was unable to find another structure in that area that was similar size to the one you're proposing here. And the reason that the reason that was brought to my attention is several times in the 6 questions, you said that there were other properties in the area that had similar structures, and I just didn't see any that were that size. Do you have addresses of those other properties?
I can get those addresses. My friend Donald Oakley on New York Street just did a 30 by 50 for his truck and his airboat. Across the street from him on New York, just a little bit further, the house is a little bit larger than mine, so I can understand, but he has a 3 or 4 bay shop behind his house as well. And yeah, most of the houses that I see when they're on an acre, you usually have a decent sized shop on it.
But as large as the one that you're proposing?
Similar size. I think his was a 30 by 50 is what Don built, which was a little bit smaller than what I would need.
Okay, because you're proposing 1950, which, 1350 or not? Oh, yeah, variance, which is, 100 by, well, anyway, it's large. What is the outside dimension that you're proposing?
30 by 65.
30 by 65, okay. Now, I noticed that your property is next to currently a wooded lot to the south, is that correct? Or am I on the wrong address?
No, I have 2 neighbors just directly next to me.
And no, okay,
And they're both in favor of me building my building.
okay. Do you have letters or anything from them?
I don't.
Stating that?
Ray was going to try to make it up here today.
Okay. Well, that's basically the extent of my questions, is it seems to be larger than what else is there. But I will open the questioning now to the other board members. Is there anyone who, Mr. Rhodes?
It's a lot of cars. Have you thought about getting an off-site facility?
I did have a shop off of Ellis for 2 to 3 years, and it just becomes very expensive. And when I would come home, and I had my son who's 7 now, so coming home and then trying to go off-site to go work on him for a couple hours and then try to do dinner and then put my son to sleep. And then after he's asleep at 8:30, I don't typically leave the house to go, down to Ellis to go work on it. So having a area where I can do that. And currently I don't have a garage at all. It's just, I have my carport, so I have a constant swap onto my driveway to try to, I did have a shop though for
How many cars did you say you have?
about 9 to 11, depending on like,
I don't know what code is for how many cars you can have on a property, but I'm sorry.
Is that a question that can be answered quickly or not?
Is there any code that limits the number of vehicles on a property?
Only if it's RV vehicles.
Okay. Thank you, sir. My concern would-
Also, if they're outside, they do have to be in working order if they aren't enclosed. And with
And
a
licensed.
license, yes.
Yeah. Are they all licensed?
currently, no, that's why I'd like to put them in a building.
Okay.
So they're not outside.
Okay. Probably my biggest concern is what you're requesting is 125% on your first request above code. That's a considerable amount of variance, okay? You're asking us to give you 1 1/4 times what, you should have on the property. Is it 2.5? Okay. 2 1/4, okay. I have concerns about it. At this point, I'm not in favor of it, but we'll see what everybody else comes up with, okay?
Anyone else wish to pose questions?
The
Mr.
information might be right in front of me, but what is the size of your house?
I want to say it's like 1,100 square foot, maybe 1070.
He's got a 759.8 square feet of living area, and the total house, including the carport, the screen enclosure, and the utility room, is 1,519.1 square feet for the total.
So, based on that, each accessory structure would be required to be 600 square feet or less?
Yes, he's required to have a minimum, 600 square feet for an accessory structure, or 50% of what the living area is, whichever is greater. So the most he can have is 600 square foot size.
But if there's multiple accessory structures, they can total up to 1,950 square feet, or no, about 1,519 square feet?
Yes, the total amount of all of his accessory structures cannot add to more than what the total for the house is. So
Have you
that's the
considered,
reason there's two different variances, one for being over the
Right.
600 and one for being the total amount of all his accessory structures, his proposed and his existing, over the total of what his house is.
thank you. Have you considered building more than one structure to be able to accommodate your needs and also comply with the code?
I did. I thought it would look a lot better having one structure and having one building that matches the color of my house, and it's nice. I have the perfect spot for it next to the house. I didn't think multiple buildings would really suit for going back and forth, and also I don't think it would look as good. And then there's got to be spacing between each building, and then I thought one large building would be the best looking.
Okay.
Mr. Chair, if I can just interrupt for a second. Paul and I were just looking. There's two existing accessory structures. His zoning district only allows for 3 total accessory structures. So in essence, you couldn't build just a couple more accessory structures without hitting that magic number 3.
He would have to take down one of the smaller ones that he has
Correct.
currently. Yeah.
Any, Ms. Parker, do you have any questions?
No questions from me.
Okay.
May I, sir?
Yeah, sure.
Have you considered doing just that, taking down one of the smaller? I don't know what you use them for, or if they're being
One
used.
is a lawn shed, and the other
Okay.
one is it's a concrete structure that I think was built a long time ago to be like maybe an outside grill area. It's got a roof on it and everything, but it's just there's no bedroom, there's no water to it or anything.
Do you use it?
I store some stuff in it, but if I would consider, tearing one of them down to have the one building,
Well,
the one larger building.
Well, that wouldn't solve that issue. What it would do is allow you then to build 2 structures to get you closer to what you're wanting, and you would only need, and you wouldn't need to have that. Well, you'd still be variance if you wanted to build 1,900 square feet, but if
So
you
what
took, if you took one of them down, then you would be able to build 2 additional buildings. You still wouldn't be able to go to that size. But if I'm reading this correctly, and please correct me, gentlemen, if I'm wrong, you could build 1,200 square feet, 2 different buildings, 600 each?
He could have 2 600 square foot buildings. All of his accessory structures, though, that he has couldn't be more than what the total of his house is.
Okay.
Each structure is limited to 600 square feet, though, because of the living area of his house.
Okay. So if you took down the one concrete building, you could put up 2 600 square foot structures, which would allow you then to stay within code without the variance. That doesn't give you the 1,900 that you want, I understand that, but.
If I tore down both of them, I could do 3 buildings.
You'd still be limited to how many you can have on your property, is
So
what we were getting at, he was getting at.
then, so I can have 3
Yes,
And I currently have,
you have 2 right now.
so if I took both of them out, and then I could have 3?
Yes, but you're still limited on their size of them.
Your
But that would
maximum,
give me
your
the 8.
maximum that you're allowed is 1,591 square feet, or 19 square feet, am I correct?
That's correct.
Oh, that's like total ever?
That's the
Yes.
total
Oh, okay.
amount you can have square footage right now without a variance.
Okay. I'd prefer to have one building, but,
Yeah.
I mean,
I understand. I do. Part of what we do is try to find a way to make it work for you, okay? And it might be a lot easier to do a variance on 3 buildings where you're asking for maybe 100 square feet more than it is, where now you're asking for 125% more than what code allows. You understand what I'm saying?
you're saying that the one building would be smaller than the 3?
No.
Or, no?
No, if you tore the other 2 down and built 3 different buildings, 600 square, not, well, you can't do 600 square feet apiece. But,
It'd be 6, 6, and 4? Or,
You could actually have 3 506 square foot, just about, a little over that,
without a variance.
without it.
correct, yeah.
But
I feel
I'm
like
just
it's-
saying, if you came back and said, hey, I want to build 3 600 square foot buildings, so you're asking for a variance of 60 square feet or 80 square feet, and I'm rounding, okay?
Correct, yeah.
For the purpose of discussion here, it might be easier to get that variance than it is what you're trying to do now. At least that's my thought, which may be flawed.
Am I reading this right, that 3 500 square foot buildings would not need a variance if he took
That's
the other
correct.
2 down?
He's limited right now. His largest he can build is 600 square feet. He can't have more than 1,519 square feet for the total, so he could have 3. So
You could
he
have
could
3
have,
500 square foot buildings,
so he could have, yes, 500 square foot buildings, 3 of them.
and you wouldn't even need a variance for that.
At all?
Yeah, it's quite not enough room, but, because I think that's.
Again,
that's-
we try to
yeah.
find options without having to do variances. It's not always the best option, okay? But we throw them out here for you to entertain. It doesn't mean that's what we're telling you to do.
Okay.
It's just our suggestion, okay?
Okay, I think that's all the questions from the board. Okay, I need to ask you to just step aside. We're going to ask people in the audience who may want to speak. So is there anyone from the audience who wants to come forward and speak in favor or opposition to this application? You look like you're ready to come on. All right, before you do any presentation, I need to swear you in. Before you do any presentation, I need to swear you in.
Okay.
So let's start with stating your name and address.
My name is Ronald Smith.
Pull that microphone closer to you there.
Ronald Smith, 2185 Michigan Street, 32904.
Okay, raise your right hand. Do you swear that the testimony you're giving us today is the truth?
I do.
Okay, you can move that microphone closer to you by bending it down.
This okay?
What that,
Push it back?
no, pull it towards you.
Get it closer to your mouth.
How about that?
That's a little bit better.
Thank you.
Okay, I heard you say opposition on the way down, but the official question is, are you speaking in favor or opposition to the application?
No.
Please proceed.
Yeah. I've lived there. I built that house 32 years ago where I live. And after I was there 2 years, I wanted a detached garage. So I set my plans in and everything, and I wanted it 30 by 24, 730 square feet. Well, it didn't take them long to tell me I couldn't have that. All I could have was 600 square feet. So I cut 5 foot off, and that's been 30 years ago, and I've been fine with it. You know, I remember when this gentleman moved in, and I understand he's got an issue, but his issue is he's bringing it all on himself with the vehicles, you know. I mean, registered vehicles especially. This vehicle, some sitting on the ground. old school bus in the back, the motor in the back. What's that there for? An old motor home sitting out there, and the guy giving that wouldn't give nothing away if it was worth anything. I mean, there's just too much there that if he built a building twice that size, none of it, all of it wouldn't go in it. He has an issue there, and I really don't know what to tell him, but the bigger building is not going to do him no good. I mean, I've lived out there, and I know people, and right around the street, he just built a garage, but he built it high, but he's 600 square feet.
Okay.
You know, and that's all I'm trying. Let him abide. It's a residential area. If he don't start commercial stuff, scraps, you know, then he should have looked into that before he bought the property. That's a residential area.
Okay. I think we've got your point.
Okay,
All right.
that's all I
Thank
need
you.
to say.
Oh, yeah, I'm sorry, we do allow questions.
Go ahead.
If he wanted to build the 3 500-square-foot buildings, would you have a problem with that?
Yeah, I wouldn't want that either.
But that
I
would be
mean,
within
he-
code.
He should go by whatever the zoning is at
Well, that would-
600 square feet.
Well, per building. If he tore down the other 2 that's on the property, he could build 3 500-square-foot buildings.
Is he going to attach them together, or are they going to be out separate?
They'd have to be separate.
They have to be separate, exactly. That's what you need to make clear.
Right.
You
But
know,
my question to you is, how would you feel about that?
I really wouldn't like that either.
Okay.
Okay.
Good
I
question.
jumped the gun, yeah.
I noticed that it was my thing on. I noticed that the other letter of opposition was last name Smith. Are you related to the other opposing party?
No, I know who you're talking about. He lives next door to me, and I've known him since they moved in there. And they're no kin to me, but I know him, and he's in opposition of it. And some other folks are too, but they just didn't come. And he mentioned a couple of names that I know them. I know those folks also, and I think if they'd had anything to say, they would have been here. But I'm trying to be good and neighborly here, you know. And he's got issues over there, but he's brought them all on himself.
Okay, thank you.
And now he's trying to work his way out of it and build. I don't care what he builds. If you let him build 2 of those buildings, what he's got wouldn't fit in them.
Okay, thank you.
They need to be.
Thank you.
Okay.
Thank you.
Thank you.
Is there anyone else in the audience who wishes to speak in favor or opposition to this application? Seeing none. Okay. Would need to swear you in. First, your name and address for the record.
My name is Megan Kern, and I actually live at that address. I do not own the house, though. So
Okay.
can I still be in favor if I don't own it?
The address is, would you state your address?
It's 2180 Michigan Street.
Okay, now I need to swear you in.
Okay.
Okay, do you swear that the testimony you're going to give us today is the truth?
Yes, I do.
Okay, you may proceed.
So I actually live on that property, and I can vouch for the fact that those cars are actually getting rebuilt. A lot of times if they are on the ground, it is because they are either getting tires switched out or they are getting parts that are coming in because they are old cars. And we do have a school bus, but we are currently in the stage of remodeling that to make a tiny house. So the vehicles that are actually on the property are getting either used for parts for those cars, or they get flipped and they get taken off the property. But there are about 7 or 8 cars that will be permanently kept in the shop just to be nice and not getting destroyed by the sun. So I just feel like I needed to say that. A few of our neighbors, like the one that you guys got the letter from, that person has multiple structures in their yard. And that are just everywhere and not covered. They're not buildings. They're just tents put everywhere. So it's kind of ironic for him to say that those things are out of place when we're trying to get one building to put all of our stuff in it so it's not everywhere. And if we don't do the one building, we'll probably do more. So I hope that our neighbors can just adjust to it. And that's all I wanted to say.
Okay, thank you. Is there anyone else in the audience who wishes to speak in favor or opposition to this application? Okay, seeing none. No, you can come back and do a closing argument.
I'm
Anything? No,
trying to like
nothing.
take it all in. It was hard. I didn't really have like a minute. Yeah, I understand that it takes me a while to build cars. Some of them I've had for 12 years now, and I'm not scrapping anything. I'm never going to have a commercial shop or anything. I work at L3 Harris. I'm an aerospace technician. I'm not a mechanic every day. I come home and I restore my cars and I work on them. It's nothing that's going to turn into any type of business ever. Like I have a career. It's just for my passion, honestly. Like, they might look like old cars to him, but a 1965 Coupe de Ville isn't. That car's worth $8 to $10 grand, and it sits outside, and each little spot of rust that I'm going to have to fix and sand down just gets worse and worse every day.
Okay, thank you. At this time, public discussion is closed. Public discussion is closed. You get one chance only. So at this point, I need a motion from, although it's District 5, as chair, I cannot make a motion, so I need a motion from one of the other board members to either approve or disapprove.
I'll make a motion to approve the variance request as depicted in the survey for discussion purposes.
Okay, do I hear a second? For the purposes of discussion, we found out last month that the chair can second a motion just to get it on the table so we talk about it. Motion has been made and seconded. Do we have any discussion further than the extensive discussion we've already had?
Well, it's a tricky one. I can understand why you're asking for what you're asking for. You're asking for a lot, though, and there's neighbors in the neighborhood that are in opposition of it, which I take into account. I think there's some suitable solutions by altering your request. I think we discussed them. But, you know, the one thing I do want to comment on is the square footage of the total accessory structure coverage of the property isn't much more than what you're permitted, even though it's one building versus three buildings. And I can't understand how that would impact any kind of flooding or environmental concerns with just the one structure as opposed to three.
I can concur with your comment about the flooding. The roof area is not significantly different between the one and the three, which makes the impervious area.
May I?
No, go, sure.
Okay. My biggest concern is I listened to what's said very intently. I heard the term flipping, which means you're taking a car to rebuild it, to resell, which makes that business use. The second thing I heard is that some of the cars are being used as parts. So you have cars that are not licensed, that are not registered, that are not working, sitting on the property that are just being used to take parts off of, to put onto either the cars that he's going to sell or the cars that he's redoing, you know, for his own purpose. I would not be in favor of this, just simply for those reasons and the fact that it's 125% over variance or over what code allows. I think we go down a really bad direction if we start allowing that big of a variance on buildings. I think he has other options. Whether if he's doing this commercially, then he needs a commercial building in a commercial location. not in a residential location. If he's not doing it commercially, then, you know, I know a lot of people that restore cars and they can't do it on their property. They do it on other buildings. So I think he has options other than what he's requesting here, so I would not be in favor.
Ms. Partridge?
I definitely understand the request because my husband is very similar in a sense that he is a car guy, but like was mentioned, he works within the zoning code to restore his vehicles as well and restores them off property. And since there are other options that I think can be considered that are within zoning laws, I am currently against this request.
Okay, thank you. I think everyone's had a chance to speak their mind here. The next thing to do is, as chair, I need to read through the 6 hardship definitions and try and summarize what we've heard and said here today. So, that special conditions and circumstances exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification. I don't believe we've identified special conditions or circumstances that aren't experienced by the neighborhood. That special conditions and circumstances do not result from the actions of the applicant. Well, yes, the request does result from the actions of the applicant. That granting the variance requested will not confer on the applicant any special privilege that is denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. My understanding of this particular paragraph is that the board is not swayed by a celebrity, either a elected official or a movie star that comes before us. And no offense meant at all, but I don't perceive that here. That literal enforcement of the provisions of this chapter will deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter and will constitute unnecessary and undue hardship on the applicant. Basically, literal enforcement, he still has other options within the zoning zoning code. That the variance granted is the minimum variance that will make possible the reasonable use of land, building, or structure. I think our discussions showed that this request is not the minimum. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Based on the opposition letters and testimony, there does seem to be a disharmony with the neighborhood posed by this variance application. With that all read into the record, I now call the vote. And let me recollect, this is a vote, the motion's for approval.
Approval.
So, all those in favor of approving this motion to approve the variance, say aye. And those all opposed?
Aye.
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 The motion is denied 0-4.
Do we, I'm sorry, Mr. Chairman, to the attorney, do we have to officially deny it, or the denial of the approval is sufficient? Do we have to come back with a motion to deny the variances?
No.
Okay.
No, if
I
you
don't think so.
If you do not vote to approve the department.
Okay, thank you. Sorry, Mr. Chairman, I just wanted to make sure we were in order there.
Good point of order.
Mr. Chair, so that motion was for the two variance requests?
Yes, sir.
Okay,
Yes.
thank you.
Mr. Bodie, may we have our second or first, whichever applicant?
Yes. Brian Keith Shropshire, request variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-2109A, to permit a variance of 2 feet over the maximum 6 foot allowed for a wall. Variance number 2, Section 62 2109C to permit a variance of 2 feet over the maximum 4-foot height allowed for a wall in the front setback. And this is in an RU-1-7 single-family residential zoning classification, and it's located in District 1.
Thank you. Would the applicant please come forward?
This is Mr. Shropshire.
Okay. First off, thank you for your patience in our reverse procedure there. We appreciate your indulgence of that. So state your name and address for the record, please.
My name is Aaron Lyons. I'm an attorney representing Mr. Shropshire. I'm with Lacey Lyons and Rizanka at 6023 Farcenda Place here in Melbourne.
I know that you're an officer of the court, but for procedural purposes, I need to swear you in.
I'm sorry, sir.
Yes.
He's also standing. You got to have him swear in as well.
Well, after, let me,
Yeah, you can have a seat. Or whatever, whatever the board.
do you swear that the testimony you're giving us today is the truth?
I do.
Okay. Now, is your associate here, or whatever?
This is Mr. Shropshire.
Is he going to speak?
Yeah, I'm going to ask him to speak whenever I'm
At that time, we'll
finished.
have to swear him in.
Okay.
Yeah,
Perfect.
okay.
And may I hand to each of you one of my,
Make sure that our staff over there gets one.
All right.
Now, if that's the packet that you submitted, we have that. Okay. All righty. Run out of desk space.
so since you've all had the application, I'm not going to, and had the opportunity to read it, I'm not going to reread it to you. One point of clarification, though, is that it's not to build a wall. That was a point of confusion from the beginning of the application process. The proposed design is it's a panel structure that looks like a wall, but it's otherwise constructed exactly like a fence. Included within the application package, we did address that and pointed out that there have been other permit applications for use of the same type of structure that have been approved as a fence. But one way or the other, for purposes of the variance request, we're just looking for the height variance for the reasons specified in the application. So the reasons, special conditions or circumstances that exist primarily arise because of the age of Mr. Shropshire's house when it was built in the mid-1980s, specifically the 100-acre Woods, a development that is directly behind and kind of on the sides of his lot was Woods back whenever he first bought the house and when the house was first built. And as the woods were deforested and taken away, all of that green buffer was taken away in terms of obviously privacy, but also with respect to sound. And then whenever the houses, in particular the 3 houses in the 100-acre Wood that border on the property, when they were built, as is typical, they were built significantly higher. Their building pads are approximately 2 feet higher, arguably a little bit more. If you look through the pictures that are attached, and I've labeled them by house number, and specifically we're talking about 6930, 6920, 6910 100-acre Woods. There's a couple of pictures in there specifically of like a pool area, and that neighbor's 6-foot fence is lower than the building pad that the house and the pool is on, and the 6-foot fence literally only comes up to like the waist of a child. So when you see the pictures of each of those houses, you're literally looking at almost the entire house above the neighbor's 6-foot fence. There's a subsequent set of pictures, and we did the pictures for two reasons. One, to demonstrate the elevation difference in the subsequently built structures, as well as to show that when the structures were built, all of the trees and the green barrier was taken away. But there's some subsequent pictures of the same pictures. You'll see in those pictures Mr. Shropshire standing outside with a 2x4 that's measured off in a 6-foot length and an 8-foot length, and then there's a superimposed black line. That black line is at 8 feet across the back and on the sides, and then there's one for the front that's 4 feet. And that's also to demonstrate not just the height or the elevation differential in these adjoining lots, but also to show that the minimum requested variance of 2 feet completely brings his privacy fence basically up to the point where a typical privacy fence would be, so that you can't look directly into the neighbor's pool and the neighbors can't look directly into his house from its higher position. In fact, there's one of the pictures of, I believe, 6930, I believe it is, or 6920. They actually have a big screen TV out by their pool. However, which you can literally watch from Mr. Shropshire's back porch. But with the 2-foot variance that we're requesting, it completely blocks that. This is a benefit not only for Mr. Shropshire, but it's also a benefit for his neighbors, all of whom arguably purchased their houses. They're higher, and they have to look over their fence because they didn't, apply for a variance. But their fence sits in the lowest area of these lots, and the building lots themselves are actually the elevated part. So it's the house that's elevated. So touching briefly on the special circumstances and conditions, obviously, these were subsequent things that happened around Mr. Shropshire, and he didn't cause them. The minimum variance, it might be possible to do a foot, but we're attempting to demonstrate today with the pictures that if you look at the 2x4 and where 6 feet is and 8 feet is, obviously you can see where 7 feet is. The 8 feet actually covers, for privacy purposes, all of the issues that are depicted in the photographs. Parties happening, and just what people do at their houses, around their pools, and so forth. But it provides privacy for both neighbors. As far as the harmony of the neighborhood, I'm not aware of any of the neighbors that complain or have lodged a complaint or a concern about having a privacy fence of an extra 2 feet on the 3 sides, and then a 4-foot one on the front of Mr. Shropshire's house. It's a benefit to them just as it's a benefit to Mr. Shropshire. The house, as it's stated in the application, is located very close to I-95, very close to train tracks, very close to schools. And again, when the deforestation and development of 100-acre woods happened, all of that sound and noise became much, much greater. So assuming that we can get the permit for this particular wall system, or even in the alternative, if we can't and have to use a wooden fence, one way or the other, that fence will buffer all of that noise. And it's not just, buffering noise is not just a benefit to Mr. Shropshire, it's also a benefit to all of his neighbors, because it's in effect replacing that green barrier that all of the trees that were once between the houses and in the building lots. It will be a buffer for everybody and reduce the noise for everybody.
As a courtesy, I would ask you to kind of summarize, end up.
And, I mean, basically, you can look through the pictures. I have the different tabs. Number 3 is a picture of the structure. And again, it is not a block wall. It's, those are panels, just like wood panels are on a regular fence. Again, I'd like to keep that issue off the table. 4 lists the dates of builds of the different structures. The 100-acre wood structures are on the second page, and the specific ones were built 2016, 2006. And then the pictures that I've attached show exactly what is viewable from and around Mr. Shropshire's house in terms of what's visible now versus what would be visible were he permitted to have this variance.
Okay, thank you.
May I ask Mr. Shropshire if he has anything to add?
Yes, I'll have to name and address, swear in.
Okay. Do you have anything?
And again, as a courtesy, well, go ahead, let's name and address for the record, please.
Brian Shropshire, 5635 Brandon Street, Boca, Florida, 32927.
Okay, raise your right hand. The testimony you're giving us today, the truth?
Yes.
Okay. As a courtesy, again, please stay on point and concise. Yeah.
Well, this is all just for privacy and noise, as he was stating. Everybody seems to be elevated higher, so if I'm able to see, they're able to see me in our yard, and I'm just trying to get that privacy. And 95 is getting even louder. I've tried contacting the proper channels, and they just told me there's nothing they can do, as in like DOT or whoever's in charge of the highway.
Okay.
I mean, that's pretty basic.
Okay. We're going to move to a question and answer portion. Do you want both or one? Yeah. All right. So do any of the, we do not have any letters of, we don't have any letters on this one. So this arises in District 1. Ms. Partridge, you have the floor for first questions.
All right, the first question I have is on whether or not you want to call it a wall, this concrete panel structure. Has this plan been communicated with any neighbors so they have the opportunity to object or support something that looks like that versus a fence?
No, and we're not requesting a variance regarding the type of structure that's being used.
Okay. I see what you're
Again,
saying.
the type of structure will just be part of the permit process, and if permitting says, no, this is absolutely 100% not a fence, and it's a wall, and you have to get a variance for it, then so be that, and we'll probably just do a regular wood fence. But again, I want to keep that issue separate from just the height issue, the 2 variances that we're asking for.
Okay. Similarly, for just the height of the fence then, has that been communicated with any neighbors? Since looking at the pictures, it would stand taller than the neighboring fences or the adjoining fence on the backs and the sides of the property, it would stand out over. Has that been
I don't know. Have you-
communicated with
Has that been
neighbors
communicated?
for support or opposition?
No, I haven't talked to any neighbors. I know a couple of my neighbors came to me and said they didn't have any oppositions of it, and they don't have any problems, but of course, I don't get any paperwork, or they're not here, so.
Okay. I'd like to open it up for other questions.
Yeah,
Can we do that?
Are you?
I think that's.
You're finished with your questions?
It for me for now.
Other board members will have questions. I think Mr. Rhodes was popping in his seat there.
Just real quick, before you turn your mic off, did you go by the property? Did you get an opportunity to do that?
No, I have not. I'm
Okay.
familiar with the area and have been on the street, but to not go specifically look at the
Okay, thank you.
individual property after receiving the
You do have your
request.
posting up on the property, correct?
Yes, whoever put it, they put it by the mailbox.
Microphone, please.
Yes, they have it there posted by the mailbox.
Okay, thank you. What is the purpose for needing a 6-foot fence in the front?
It was for noise and, what do they call it? Just like you have a 6-foot fence in the rear and a 4-foot fence in the front, cohesive drop. So instead of having 8 to 4, it's not going to be cohesive, and it helps with all the noise from 95 and everything.
Well, that being said, you are a minimum of 10 houses from 95 plus the green area. You know, probably for right up against 95, I pretty much understand you want to do whatever you can.
It
But
wasn't.
being that far away from 95, I don't see that that's going to make that big of a difference. And getting 2 feet more is going to stop, you know, any noise coming that direction. And again, if you were right against 95, yeah, I can understand, because you can block headlights, et cetera. But you're not. You're deep into the community there.
Well, also, we have several homes that were just built between me and 95. That took out all the buffer green, too.
I understand, but you've got 10 homes
It's
between you
not-
and 95 that are blocking sound. My second concern is that if we allow you a 6-foot fence in the front, then that could be where neighbors backing out of their driveway could hamper them from being able to see traffic coming down the highway or down that road. That would be a concern of mine as well,
It's set for a 15-foot setback.
right? Still, if I'm backing up, I'm not going to see it till I get to the sidewalk. If somebody's walking down the sidewalk, I'm not going to see them because the 6-foot fence is going to block me from being able to do that. Same thing with a car coming down the road. I'd love to say everybody drives the right speed limit, but you and I both know they don't. And so you're backing up, you know, if you're pulling out forward, it's not a problem. But if you're backing up, it becomes a problem. And that 6-foot fence would create a line of sight problem. And that would be my concern with going to 6 foot in the front. You know, when we get to motions, I'm going to ask that they break these up for that reason.
Yeah, I was going to.
Because I think the fence in the front is an issue. I think it's a health and safety issue. And I would certainly not be in favor of the one up front. I understand your reasonings for the one in back. I'm debating that in my head at the moment, okay? But it's more understandable to me, though I don't think it's going to make a sound difference. Your privacy difference would definitely come into play. I have a 6-foot fence on my property. Unfortunately, I have hills, so I had to go into the ground to stay at that 6 feet. And, you know, you can walk up to my fence and look over it, but that's code, and that's what I stayed within. But anyway, that's all I've got. Thank you, guys.
Mr. McCann?
Do you have any addresses of neighbors or homes in the neighborhood in which there are 8-foot fences?
I don't believe so.
No, I don't think so in our neighborhood.
And what about 6-foot fences in the front?
No.
Thank you.
They asked all my questions, so I'm going to stand down. At this time, I have to ask the audience for, so if you could just take a seat or step well aside. At this time, are there anyone in the audience who wishes to speak in favor or opposition to this application? Seeing none, please return for any summary of your presentation.
Just in summary, I believe that we've addressed each of the points of the definition as related to undue hardship. I think that the most compelling reason in particular, and again, I agree that we definitely want the variances to be split apart, just like I'm trying to keep the fence type separated from it so that we can just see what variance we can get on the height. The back is by far the most important, but in particular, it is not only uniquely needed for Mr. Shropshire because of his elevation, but it's a benefit to all the other neighbors as well. So it will add to the consistency of the neighborhood. And as it is right now, one of the things that we did not mention but is also important is because of those really unique privacy issues, where literally 3 neighbors look down in on Mr. Shropshire's property, and he has to look like at people from the knees up at their pools. That does impact the value of his property unnecessarily. That can be remedied with the 2-foot variance, at least on the back and sides.
Thank you. I have a procedural question. Do we need a motion to separate this into 2 separate portions of the application, 2 votes? Yes, okay. I think a general sense is this is probably something people favor, but I need a motion to separate these 2 applications, well, this one application into 2.
Question?
Yeah.
Can you make a motion that would incorporate both? Say, if you wanted to make your motion, but make it as such that,
There's
for
two-
example, if I approve, I make a motion that we approve variance 1, but disapprove variance 2. Can that be in one motion, or do they have to be split?
It would be cleaner to have it split.
Okay.
Okay. With that point of order, do we have a motion from someone to split the application into 2 parts?
I move that we split the application into 2 parts.
I'll second that.
Okay, Ms. Partridge has made a motion to split the application. Mr. Rhodes has seconded it. I'll ask if there's any discussion on that. Seeing none, call the vote. All in favor of splitting the application into 2, say aye.
Aye.
Any opposed? I'm hearing none. We are going to split this into 2 separate applications. So we can have board discussion. Thank you. So now, portion 1 of the application, we need a motion to approve or disapprove.
I'm just verifying what we're calling portion 1, if that's the front fence or the back fence.
8-foot fence around the back and 6
Okay.
foot in the front.
Variance on the 6-foot fence.
Okay. So I'll make a motion to accept the variance for a 2-foot variance on the 6-foot fence, allowing a total of 8 feet.
That would be for variance number 1.
For
Variance
number
1.
1.
Yep.
Yeah. Second?
As depicted on survey. Thank you.
And a second?
I'll second.
Okay, Mr. McCann has seconded. Let's have any discussion, any further discussion we've already had.
Just a couple quick points I'll make. Number 1, as far as sound, the 2 feet isn't going to make a difference on sound, especially as far away as, when he said he was close to 95, I went to the map and looked, and he's not close to 95 where that wall is, or fence is going to make a difference. I guess my second thing, and I more understand the back than I do the front. I really do, and I can appreciate it. But if it's already only at knee height at 6 feet, if you give it 2 feet, it's still only going to be waist height. They're still going to be able to see over and look over, and I think it's going to be out of harmony with all the other fences in the area. And that's just my opinion.
Okay, any other comments?
Mr.
Discussion?
Chair, I just need to bring, so the request is for a wall, and I know that the applicant did not want to go there. However, the way that the code is written, the description between a wall and a fence are two different things. I don't want to make sure that your motion is for a wall, because if not, there's a very high potential for this to be reheard, because you are making a motion for a fence when the construction clearly is not defined as meeting the fence. So I would strongly urge you in your motion to call it a wall, because our code says that there's 4 materials that can be used for a fence: wood, metal, ornamental iron, and PVC. This is a precast concrete fence, so I just wanted to, so everyone understands, so that way when we're trying to do the permit and the variance was for a fence and it's a wall, that they don't have to come back and hear you again for that.
So clarification then, please. So not only they're asking for 2 feet, but they're also asking to do a wall instead of a fence.
Well, they don't need a variance for the wall.
Okay.
It's purely a height variance, but when they're getting a variance for a wall versus a variance for a fence, 2 different things.
So then if they were not allowed to put up the wall, they'd have to come back to get a variance for a fence if they were going to do a fence?
Correct.
Okay.
So, Ms. Partridge, could you amend your motion, please?
Yes, so I'll amend my motion to accept a variance for a wall of 2 feet over what is currently allowed, as
Okay,
depicted by survey.
All right.
I hope I
Second?
got that right.
I'll second it.
Okay. Amended motion by Ms. Partridge for the 2-foot over height wall, seconded by Mr. McCann. Any discussion on this portion of the application?
Well, at this point, just one more thing, I'm sorry. Now with it being a wall, it's definitely out of harmony with the rest of the area, because all the pictures that we've seen are all a wood fence and not this type of wall, though I think it is very pretty. It would not be in harmony, in my opinion, with the rest of the area.
And I'd like to comment on that as well. I do have concerns that that would make it look more commercial than residential. Even though it's along the back, it would be an odd thing if it's standing taller than the structures that are adjacent to it.
Any comments, Mr. McCann?
No.
Okay, I don't really have any comments. With that, we have a motion to approve for the wall 2 foot higher. We've had board discussion. I need to read the 6 hardship responses or summary. So, that special conditions and circumstances exist which are not applicable to other land structures or buildings in the applicable zoning classification. I did hear some discussion about elevation, so this may be slightly different than what is in the surrounding lots or parcels. That the special conditions and circumstances do not result from the actions of the applicant. A little mixed here in that circumstances of construction have built up around him after initially occupying. The request for a wall is a result of your actions, but the circumstances that led to it are not. That granting the variance requested will not confer on the applicant any special privilege as denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. As I mentioned before, that is to exclude our sway by elected officials, celebrity, something like that. That literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter, and will constitute unnecessary and undue hardship on the applicant. Literal enforcement will deprive applicant of rights commonly enjoyed by other properties. No, I think that his property is similar to the rights of the other properties in the neighborhood. It's a difficult one. That the variance granted is the minimum variance that will make possible the reasonable use of land, building, or structure. Here, the word reasonable comes into effect. It depends on who's making the reasons. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such use variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Well, I've heard about traffic sight lines, and I've also heard about the effect of what would look like a wall versus other barriers, property edges in the neighborhood. So, with that being read into the record, I call for the vote. This would be, I think it was approval. So, all in favor of approving this application for the height variance of the wall, say aye. All opposed?
Aye.
Aye.
Aye. That portion of the application has been denied by a vote of 0 to 4. So now we need a motion for the second half of the application, which would be the 2-foot taller wall in the front of the property.
I'll make a motion to accept the variance on the front half of the property for a 2-foot variance on a 4-foot height for a wall as depicted by survey.
Any second?
I'll second.
Okay. Ms. Partridge has made a motion to approve the second half of this application. Mr. McCann has seconded. We can now move to board discussion, and Ms. Partridge, your district, you can start.
I think we've had enough discussion on the front half of the variance, so no further comment from me.
Okay. Anyone else? It's unusual. Okay, so board discussion is finished. We've read the 6 hardship questions. I'm going to call, oh, no, whoa. Okay, we finished the board discussion. I think I'm going to
you don't
refer
need
to my previous reading.
That's correct.
That pretty much summarizes everything again. So I'm going to go straight to calling for the vote. All in favor of approving the additional 2 feet to a wall in front of this residence, say aye. Any opposed?
Aye.
Nay.
The motion is denied by a vote of 0 to 4. Mr. Bodie, may we move to our next applicant, please?
Yes. Item number 3, Ronald Benjamin and Victoria Driggers request variance of Chapter 62, Article 6, Brevard County Code, Section 62-2118D3 to permit a variance of 4 feet over the maximum 14-foot projection, 20% of the width of the waterway for a boat dock in an RU-1-11 single-family zoning classification located in District 2.
Thank you.
Well, also, I'd like to mention that there was a 500-foot radius mailed out to on the property for instead of a 200-foot radius, and the people that wrote in were in that over that 200-foot radius. But anybody can write in whether they request approval or disapproval of it, no matter what distance you are from the property.
Is this one that we got letters on?
Yes, you have
Okay,
2 letters, two letters on it.
okay. So
You've seen them.
let's, you've seen the procedure go on here. I need to name and address for the record, please.
Ronald Driggers, 1705 Cecil Drive.
Okay, and raise your right hand. Do you swear that the testimony you're giving us today is the truth?
Yes.
Okay, how can we help you?
So I'd like to pass out some presentation materials.
One copy certainly to staff, and
So I'll be brief.
Thank you.
I'm not going to go through this whole package. So as discussed, we're asking for a 4-foot variance. So instead of 14-foot, maximum dock projection would be 18-foot. If you go to the first page there, you'll see the overview of the canal with the house listed there under the green arrow. The next page is the proposed dock, and you'll see the 18-foot projection there, which is the subject that we're talking about today. So just the next page is some rationale for why I think this should be approved. So the bulkhead, that is the seawall, and the property line are offset by 4 foot. This is not a result of our actions. The bulkhead and the property line were not aligned when we purchased the property earlier this year. The proposed dock will not project into the waterway any more than existing structures on the north side of the canal, and will be in line with my neighbor's, the west neighbor's dock. So navigation will not be impacted in any way. Greater than 35 foot of canal will remain, and this is sufficient to allow 2 typically sized boats to pass, no problem. It is a short, dead-ended canal, and it's rare that two opposing boats would need to pass at our location. It's not going to be the narrowest point in the canal, or any narrower than the existing canal entrance. And so literal enforcement will deprive us of the size and style of dock commonly enjoyed by other properties along the canal. So the next page is just an overview, and you'll see where those measurements are. The canal entrance is approximately 35 feet. Our proposed dock would be about 35 feet. There's a narrower point down the canal at around 31 feet. And these are as measured on the Brevard County Property Appraiser's website. So there's plenty of room for boats to pass. And then the next page is just projections into the waterway of other docks. So these measurements are shown to illustrate that many of the docks along the north side of the canal protrude into the waterway the same amount. The dock to my west isn't an outlier or projecting any further along the canal. And we're not going to go any past our neighbors. So I can guarantee that we won't be 1 inch past where our neighbor's dock is. So I hope it's been evident that my wife and I have been working hard to ensure that we're doing things the correct way and not asking for anything unreasonable. Thank you for the time, and looking forward to answering your questions.
Okay. Your application rises in District 2, represented by Mr. McCann, and so you have the floor for questions.
Thank you. I did visit the property yesterday and observed myself the information that you're providing. There's no dock yet at this particular property, but there's a next door neighbor's dock that I was able to walk out on and look left and look right and see that that neighbor's dock protrudes no further out than other docks, and then yours would be the same distance out from the seawall as your neighbor's dock. It wouldn't protrude out any further.
That is correct. Not a single inch past that.
Okay.
Yep.
And the 14 feet of dock that you're wanting to build would be sufficient should your seawall be at your property line.
Yes.
But because your seawall is built 4 feet out of your property line, you need the variance because the property line is where the measurement begins.
It would essentially be unusable. It'd have to be less than 10 feet, which would be a tiny boat at that point with the lid.
And I did notice what you're saying about boats passing by. I think if you have 35 feet of distance between the furthest protruding dock on your side and the furthest protruding dock on the other side, that'd actually be enough room for 4 boats to pass by at the same time, which will obviously never happen, but I'm comfortable with your application. One more thing. This is a dead-end canal, correct?
It is,
Okay.
yes.
Thanks.
Any other questions?
Mr. McCann, are you saying that his seawall is out further than the other properties? Is that what I'm understanding?
No, the seawall itself, It's such an old neighborhood. With the original seawalls, I don't think are even being used anymore. More seawalls have been built, and then they would build them beyond the original seawalls to maintain the integrity of the property and not take a seawall out to replace it. So his property has at least one seawall that's covered up under the ground, and that's probably where the property line would be. But this seawall that he has now is built further out, so it's 4 feet out from the actual property line, which is consistent with the neighborhood. I think actually the house right next door, their seawall goes out just a little bit further than this property.
But his 18-foot would not protrude any further than the other docks in that area, in your opinion?
No, it would be 18 feet from the property line,
Okay.
14 feet from the seawall.
Okay.
And the
I just
neighbor
needed
seawall-
to understand, and since you've been there, that you were the best person for me to ask that question to. Thank you.
Can I
My-
clarify
My
that too?
understanding of the code is,
Yeah, the neighboring seawall was actually protrudes a few inches past, so they're almost in line, but not quite.
no, that's okay. My understanding of the code is that they're allowed to build 18 inches off of the face of the previous seawall, and if it's happened more than once, then that begins to creep out into the waterway, and that could justify the 4-foot difference. I have no questions. I defer to my boating friends. I'm not a boater. Do you have any questions?
No questions.
Okay. A brief final summary, if any? Oh, I'm sorry. Were there more questions?
No, you have to ask for anybody in the audience.
Well, okay. All right. Well, please step aside and I'll ask. Is there anyone in the audience who wishes to speak in favor or opposition to this variance application? Yes, we have a hand raised. Please come to the microphone. I need to get your name and address and swear you in before you speak. Pull that down to yes, ma'am, right there.
Okay.
Could you state your name and address for the record,
Cheryl
please?
Jorgensen, 1625 Seashell Drive, Merritt Island, Florida.
Okay. Raise your right hand. Do you swear that testimony you're going to give us is the truth?
Yes.
Okay. In favor or opposition to this?
Opposition.
Opposition. Well, no, go ahead.
Okay. Well, in fact, it didn't say that the variance was from the seawall or the property line. It said it couldn't go 20%, it couldn't project more than 20% of the width of the waterway. So the width of the waterway obviously has gotten smaller, and as people have to replace their seawalls, it can be another foot or two more into the waterway. And I'm in the process of selling my house to some people that have a big boat, and I'm concerned that if this is allowed, then, and that would be a precedence that other people would be allowed to make wider docks. And then if they park their boat on the outside of their dock at any time, sometimes the boats probably can't get in. So that was my concern, that if everybody can put their dock another 4 feet out, then it would be more than 20% of the waterway. And from Google Earth, it appears that our canal is only 6.5 feet wide and not 7 feet wide. So, or 65 feet wide, not 70 feet wide. Do it with the calculations of the scale that Google Earth has put out. Would you like to look at this?
If you could just hold, well, that's all right. I'm going to ask our staff, the definition of the width of the waterway.
What it is this is a platted waterway. It's platted, the canal is platted at 70 feet. So the distance measured for his projection is measured off of his property line. The seawalls have been built into the waterway, so the actual water distance is going to be less than that 70 feet. It's just like a road right away, though, being 50 feet. you own right up to your property line of the 50-foot right-of-way. You still might maintain up to the asphalt on the right-of-way by cutting the grass or something. But this is where it's measured at in the code. It's measured at where the distance of the width of the water of the platted subdivision.
It's measured from
It's measured from the
property line to
yes.
property line,
Yes,
not seawall to seawall.
correct.
So I just wanted to make sure you understood the regulatory definition of the width of the waterway is the property, not the open water
Okay.
distance. Second, parking a boat outside of the dock, is that a legal
No, the
practice?
projection includes any boat that's parked there. It can't be more than the 20%. So if you park a boat on the outside that's further than the 20%, you have a code problem that somebody could call in.
They could call into law
Yes.
enforcement to,
Code enforcement.
code enforcement?
Yes.
All right. I hope that helps.
Yes, but I mean, if they have the boat there for getting on and off, I mean, I wouldn't think they'd want to park it on that side, but, you know, because we do have people in the canal that have covered docks, and they park it on the outside of the dock, getting in and out of the boat, and, you know, when they have company and stuff, so.
It sounds like a code violation, and there's
Right.
procedures for that.
But that's down the canal. It doesn't interfere with people trying to get in and out of the canal, was my point, so.
Okay.
Okay.
Anything else? I don't want to,
No, that's all I have.
okay. Thank you. Oh, wait, did we have questions for this?
I do have a question.
Yeah, I'm sorry.
Thank you for coming in and
Yes.
taking your time to address an important matter. I'm understanding, I think it's similar to some of the other letters of opposition, that you're concerned about the precedence of allowing a dock to be built out further than what's the code requires for navigational purposes and safety purposes. And we're not trying to set precedents necessarily, but we take every case on a case-by-case basis. And in this particular case, we're just looking at their circumstances. Are you concerned about the navigation right now in the canal?
Well, like I said, I'm selling my house to some people that have big boats, so.
Well, if there's 35 feet of width in that canal, I mean, I don't know of any boats that would impact. I'm just wondering if their structure, if their dock is not built out any further than existing docks, how would that impact the navigation now until then?
I don't know.
All right. Thank you.
Is there anyone else in the audience who wishes to speak in favor or opposition? Please come forward to the microphone. And please adjust the microphone to your best, and I need your name and address for the record.
Catherine Patrice Roseland. I live at 1635 Seashell Drive, Merritt Island, Florida, 32952, next door to Sherry.
Okay. Raise your right. Do you swear that the testimony you're giving us today is the truth?
I do.
Okay. Please proceed.
Just in general, I do know the names of the other two people that have sent in letters that have had the same concern, and I just want to voice my concern, like Sherry, that it sets a precedent for building out beyond what is code, and that's just in general, and that's the only issue I have.
I didn't officially ask you if it was in favor or opposition, but I'm taking it you're in
Opposition.
opposition.
Mhm.
Okay. Board member questions?
Just thank you for coming in and voicing your concerns. I think it's important that you have that forum, and what you have said has been taken into account.
Okay, thank you.
Thank you. Is there anyone else in the audience who wishes to speak in favor or opposition? Okay, please come forward, adjust the microphone for best use.
Hello.
Need your name and address for the record?
Jim Dorr, 1700 Coquina Drive, Merritt Island, Florida, 32952.
And raise your right hand. Do you swear the testimony you're giving us today is the truth?
Yes, sir.
Okay, please proceed. Did I ask you favor or opposition?
Favor.
In favor, okay, thank you.
Well, I can understand their concerns, obviously, but the dock isn't going out any further than the other docks. The problem is his property line is 4 feet in from the waterway, so he has a problem. He couldn't build a dock if it was started from the property line, but it's 4 feet from it. So his dock is going to be exactly the same as everyone else's dock. It's because his property line is 4 feet back in from the water. You know, that's not his fault. But the docks are all going to be at the same protruding into the water. So his dock isn't going to be any bigger than anyone else's dock, is my point. I live right across the canal from him.
Okay.
So it would impact me if he built it 4 feet further into the water, but he's not doing that. They're all going to be in line. It's just because his property line, which is where you're supposed to measure from, is different than everybody else's. If that's got to make sense, right?
Yeah, we understand that.
So that's all.
Okay. Any board?
Again, like the other two ladies, thank you for coming in and spending the time to voice your concern.
Okay. All right.
All right.
Thanks.
Thank you. Is there anyone else in the audience who wishes to speak in favor or opposition to this application? Quickly seeing none. We will invite the applicant back for any closing argument and summary.
No, I could certainly understand how, without context, there would be concerns. But I think it's a very important point that I'm not trying to do anything, that other people haven't done. In fact, quite a few people have already done as far as a projection. So we'll be right in line with everybody else. It can't impede the waterway any more than it already is. So if you can get a boat down there now, you can get a boat down there after we build the dock. So that's all.
All right. Thank you. At this time, the public discussion is closed and the action moves to this side of the bar. The first step in our discussions is to have a motion to approve or deny this application as depicted in their application on the survey.
I'll make a motion to approve the variance request as depicted on the survey.
Okay?
I'll
Do we have
second.
And, all right, Mr. McCann has made a motion to approve. Ms. Partridge has made a second. And we move to any board discussion. I'll open the floor with you, Mr. McCann.
I accidentally made my discussion during the question and answer time, so we'll just go. I'll repeat that.
Okay. Anyone else?
Just a question, if I could, please. We are hearing from them that his dock will not protrude any further than the others in the area. Are you able to confirm that?
No, we don't have a survey that shows any of the other ones. There is one survey that he provided that locates, it looks like the one that's right to the west of him, and it'll be right in line with that one. But we don't have any other
Okay.
surveys to show that.
But it would be in line from what you've seen to the one next to him?
That's what the survey appears to show whenever
Okay.
you look at it.
Okay. I just wanted to, because no offense to anybody, it's just, when we're hearing that, it's opinion, and opinion's great, but then when it gets built and it sticks out further, then, we're approving or disapproving depending on whether it is in line or not in line, at least for me, okay? So that's the reason I asked that question. I just want to make sure, because if it's in line, I don't have a problem with it. If it sticks out further, I do. So that's my reasoning.
Mr. Chair, if I can just, so we did look at, Paul and I looked at the survey. It does not show any dimensions on there. It looks like it's in line. However, I would caution you, we do not have the permit history of if that dock got permitted. But
Right.
from what that's shown, it looks like it's in line.
Okay.
Again, I'm not a boater, but this looks like similar situations we've run into in the past. I'm not all that in favor of building a seawall in front of a seawall in front of a seawall, but apparently that's legal and part of code. So I have really no opposition to this. So we have a motion to approve. We've had board discussion. Everybody's had their say. Okay. And now I have that obligation of, that copy. I have to get something else to read off of here. All right, this is my summary from the discussion of the 6 hardship questions. That special conditions and circumstances exist which are not applicable to other land, structures, or buildings in the applicable zoning classification. No, there's nothing special here. We've seen this before. That the special conditions and circumstances do not result from the actions of the applicants. I failed to ask who built the seawall in front of the seawall in front of the seawall, but being that that's the existing condition, yes, the actions of the applicant are asking for a variance, but he's working with an existing condition. That granting the variance requested will not confer on the applicant any special privileges denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. As I stated before, we're not swayed by celebrities or elected officials here who are making presentations, no offense, but I haven't seen you on TV lately. That literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification of the provisions of this chapter and will constitute unnecessary and undue hardship on the applicant. A literal enforcement would deny you of rights commonly enjoyed by other properties since there's existing conditions that appear to be just exactly what you're asking. That the variance granted is the minimum variance that will make possible the reasonable use of land, building, or structure. I believe that 14 foot is a standard dock width, and so that would be the minimum variance. The granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such use variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Not being a boater myself, but hearing the discussion from other board members who may be, they seem to think that this is not a safety hazard. So with those 6 hardship questions asked and answered, we will move to the vote. So all in favor of permitting this additional width per the application, say aye.
Aye.
Any opposed? Then the motion passes 4-0. We have 4? Yeah, 4-0. And your variance is approved. I would like to ask for a 5-minute recess so everybody can stretch their legs a little bit. We've been at it for an hour and a half now. So, do I need a motion for that, or can I just call it? I'm calling it. I have to make a phone call. To call back to order this meeting of the Brevard County Board of Zoning Adjustment. And if you'll wait, I still have to get Mr. Bodie to read your application. So at this point, Mr. Bodie, may we have the next applicant, please?
Yes. Daniel Nastyn, request variance of Chapter 62, Article 6, Brevard County Code, Section 62-2123A, to permit a variance to allow a swimming pool to be located forward of the front of the principal structure in an SEU, Suburban Estate Use Residential Zoning Classification, and this is located in District 1.
Okay, thank you. Could you state your name and address for the record?
Jerry Knerr, 1220 South Carpenter Road, Titusville, Florida.
Okay, raise your hand. Do you swear that the testimony you're giving us today is the truth?
I do.
Okay.
H4.
How may we help you?
All right, so I'm a contractor for Daniel. I'm not doing the pool. I was doing some other work on his house. And when I came over a couple of months ago, he brought this to my attention that he was showing me the placement of where he wanted to put the swimming pool and where they drew the line for the front of his house. And of course, I asked him the same questions that you guys are asking. Well, why can't you put it here? Why can't you put it there? And well, one place he has that he could put it is his septic system, so he can't put it there. And he's on that part of Carpenter Road, it curves, and all the houses that sit on Carpenter Road they face the road straight. Well, when you come around the curve, there's 3 or 4 houses around the bend that they sit catty corner to the property. So the corner of the house is facing the road. So instead of it sitting flat against the road, it kind of sits on about a 45-degree angle. So instead of it being this being the front of your house, and I have a blown up, you guys have this survey. Yeah, I have it blown up if you want to see it. One of the problems with putting it in the back, and I have some pictures here blown up, is when it rains, the adjoining property to the south, the elevation is probably about 20 to 25 feet higher than his. So if he was to build it in the back where the stormwater collects, it would divert all that water to the back neighbor and just flood his property. Plus, the amount, it wouldn't be cost advantageous to build all those retaining walls and to divert all the stormwater. There's just nowhere for the water to go. You can't pump it back uphill. There's nowhere for it to go. It would just run back down. There's not a proper stormwater system in that neighborhood with, P-traps and field drains, and it's just all watershed and natural water flow. So really, the only place he has to put it on his lot is on the front corner of his house. And if you were to look at the survey and the way it sits, it's, like I said, this is what they're calling the front of the house. And the house sits catty corner. So he's not really proposing to put it anywhere, he's not really proposing to put it past the front of the house. It's just the way the house sits on the lot. There's really no other place to put it.
Okay. We've received no correspondence on this application.
Yeah, we've communicated with the neighbors. He's relational with all the neighbors. They're all in favor. They don't have any issues with this. He also proposes to put up a privacy fence in that area to keep that, and a screen enclosure to keep that area cordoned off from public view. I'm sure he'll put some hedges and bushes around it too to make it look nice.
So your application arises in District 1. Ms. Partridge, you have the floor for any questions.
I have no questions on this request.
Okay. Any other members?
I just have a couple quick questions.
Mr. McCann?
I'm looking at the survey. The front of the house actually faces on a diagonal, not quite the road. Is that right?
Yes.
So The way the plan is the pool itself is behind the front face of the house at least.
Yes.
And then the only part of the pool that protrudes closer to the roadway than the front corner of the house would be that small triangle up top.
Yes, and it's still 100, right now the setback's around 105 feet from the front of the house to the road. With the pool, I would think it would still be well over 90 feet of the setback to the road to the front of the pool.
All right, thank you.
Any other questions? Okay. I need you to step aside. And is there anyone here who wishes to speak in favor or in opposition to this application? Seeing none, you can return.
Trying to keep it simple for you guys. You've had a hard enough day.
Yeah, thank you. Last words.
Again, you know, with given the characteristics of the property, you know, it's pretty cut and dry with the elevations and the storm water. I've been there. I have pictures of it where the water retains in the back. There's just really no other place for him to put it. And given the placement of his house, it just makes sense to put it where he's requesting to put it. It's pretty cut and dry, I think.
I do have a question I wish I'd remembered to ask before. You mentioned that stormwater is running off the neighbor's property onto your property?
Well, yeah, yes, it does, because his driveway goes up. It starts at the road elevation, and it goes up. So all the stormwater comes down into a swale, and it goes into his backyard, and that's where it sits.
From his own property?
From the neighbor's property, from the adjoining property. That part of Carpenter is the topographical elevation change is drastic. I mean, one lot will be 30 feet down here, the other one can be 20 feet up here from, calling the roadway a zero. So it changes drastically. So if you were to put the pool in where you can see maybe in the back of the house where there's another place you could put it, that's where the stormwater, retains. Plus, he has a third floor, he has a basement in the house. Because of the way that the property runs downhill, there's a basement. So if you were to put the pool anywhere in the backyard, you wouldn't have a main level entry from the house to the pool. It would almost be underground because of the way the property runs downhill.
The purpose of my question was more not so much the location of the pool, but anyway, you may want to think about that as a separate issue, that you're not, I don't think you should be taking stormwater from your neighbor.
Yeah.
But let's let that lie and just bring it up to your attention.
Thank you.
So that was your final summation. Thank you.
Thank you.
Now, no, I didn't see any. All right. So it's been a long day. You can have a seat. We're going to, do I hear a motion to approve or disapprove this variance application?
I make a motion to approve this variance application.
I'll second.
Okay, motion has been made to accept the application, to approve the application as depicted on the application and the survey. Been seconded by Mr. Rhodes. And at this point, we can have some internal discussion here with the board.
I'll just note real quick that, I'm very familiar with Carpenter Road. It has properties that run deep. It has those hills like you mentioned. I don't think this will interfere with the neighbors or the look of the neighborhood or anything like that, and I think it's a logical location, so I am in favor of this request.
I myself have no problem with the variance. Obviously, I expressed my concern about the stormwater issue, but that's separate. No more discussion, then I will read the summary of the hardship questions. That special circumstances and conditions exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification. Not knowing the topography there, but it sounds like it varies, and so it special circumstances do not exist. That the special conditions and circumstances do not result from the actions of the applicant, bought the house in place, so you're just looking for a variance on future actions. That granting the variance requested will not confer on the applicant any special privilege, and that relates to celebrity and elected officials. I don't see that as being applicable here. The literal enforcement of the provisions of this chapter will deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification of the provisions of this chapter, and will constitute unnecessary and undue hardship on the applicant. I haven't heard any opposition to that the literal enforcement would that the literal enforcement may deprive the applicant of rights commonly enjoyed by other properties in the neighborhood. That the variance granted is the minimum variance that will make possible the reasonable use of land, building, or structure. I believe this is the minimum. We're just dealing with the corner of the swimming pool. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. I don't see any injurious or detrimental effects from approving this variance. So with that all read into the record, I will call the vote. All in favor of approving this variance application, say aye.
Aye.
Any opposed? And the application passes 4-0. Mr. Bodie, may we have the next applicant, please?
Yes. Espejo Investment Group LLC requests variance of Chapter 62, Article 6 Brevard County Code as follows. Variance number 1, Section 62-1342-4 to permit a variance of 4 feet from the 50-foot required lot width for the RU-1-7 single-family residential zoning classification. Currently, the property is zoned AU, agricultural residential. Variance number 2, Sections 62-1342-5A to permit a variance of 0.5 feet from the required 5-foot side south setback for the principal structure, and this is located in District 2.
Okay. The applicant has already approached the podium. Could you state your name and address for the record?
Hi, my name is Michael Espejo. My address is 9241 Chelsea Drive North, Plantation, Florida, 333124.
Okay. Raise your right hand. Do you swear that the testimony you're giving us today is the truth?
I do.
Okay. Please make a presentation.
I bought this property for an investment, and the property is zoned agricultural, and I am not going to be granted any permits, specifically for a fence, until it is reclassified as RU-17. So this is the first step in that. And I found out that it's a little bit smaller, the lot width. So that's the variance. And I guess also the property, the main structure is a little bit closer to the property line than it's allowed. So second variance. And that's it.
Okay. Okay, we have not received any letters in opposition or to this. We can move to board questions. Mr. McCann, this is in District 2, your district?
It is. I drove by the property this morning and had the opportunity to observe what you're stating. There is a structure on that property now. Is your plans to remodel that structure or tear it down?
To remodel it.
Okay. I don't have any other questions.
Any other board members? Okay. So if you could step aside, is there anyone here who wishes to speak in opposition or in favor of this application? Seeing none, please step back to the microphone. Any last, final words?
No?
Okay, that's good.
Make it short and sweet,
Let's not
pretty
dry
cut
it
and
out.
dry.
Okay, please take a seat. All right. This application arises in District 2, but any board member can make a motion to approve or disapprove.
I'll make a motion to approve the 2 variance requests as depicted on the survey.
I'll second.
Okay, the motion has been made to approve both sections of this application, seconded by Mr. Rhodes. And is there any other board discussion that we would like to?
I'd just like to add, my opinion, this is strictly opinion, is I think a residential use would be a more appropriate zoning for that property. It's a very narrow piece of property, and there's not much you're going to be able to do with it, especially in the agriculture world. The home is already existing. We don't plan on tearing it down. So the problem with the home is it's just built a little too close to the south property line. So we're really legitimizing that.
Yeah, my thoughts exactly. It already exists as it is, and half a foot is pretty nominal. Even the 4 foot on the 50-foot width is pretty nominal as a variance. I thought it was going to RU 117. It's currently zoned agricultural, so it is going to a residential zoning?
That will be, I assume,
Well, that's his process, but he has to get this in order to even
Ah.
move forward with that.
Okay, but that's the intention, and I think that fits the neighborhood. Any other discussion among us?
No, it's just, we don't allow him the 4 feet from the 50 foot, then he can't use it, and that's our undue hardship clause, so.
Yeah. Okay, we've had the board discussion. Let me try and briefly and quickly go through the 6 questions. The special circumstances and conditions exist which are not applicable to other lands in the zoning area. Special circumstances exist in that it already is an existing lot that's platted. So it's yeah. The special conditions and circumstances do not result from the actions of the applicant. No, it was originally platted that way. The granting the variance requested will not confer on the applicant any special privileges denied. This goes to the celebrity, and I don't recognize you from any movies or elected office. That literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification. Literal enforcement would deny you or deprive you of rights, especially this minimal and nominal request. That it is the minimum variance, yes, we believe it's the minimum variance to just legitimize the existing condition. That the granting of the variance will be in harmony with the general intent and purpose of this chapter. Yes, we believe it is. So, having briefly read those in, I will call for the vote. All in favor of approving this application, say aye.
Aye.
Any opposed? The application is approved. Mr. Bodie, I understand that the next 3 applications are by the same applicant. Are they like contiguous properties, or?
Yes, they're all on different properties right now, but it's for going to be a project that is going to combine them all. We're being heard as individual applications right now for each of the signs. They are for 3 different sign variances.
I'm asking whether we can discuss them all as one and then have 3 separate votes at the end.
You can do that. It's your preference
Motion?
to do that. Since the conversation is probably going to overlap a little bit, but just make sure in your motion that you clearly delineate for which one that you're making the motion for.
Okay. We will make 3 separate votes, but I'm only going to do 1 hardship reading, and we will have the discussion of all of them.
I don't see an issue with that.
Okay.
So we
Does that
will
require a motion?
I don't think so, no.
Okay.
So
Good.
Paul will read all of them together, and then you can just make them, make your motions accordingly.
Okay, thank you. So, Mr. Bodie, you're up. All three applications, please.
Okay. Jerry and Kane Watson, request variance, Chapter 62, Article 9, Brevard County Code, Section 62-3316B4, to permit a variance of 8 feet from the 15-foot front perimeter setback for a sign and a BU-2 retail warehouse wholesale zoning classification located on District 2. Second sign variance application, Mike Erdwin Motors, Inc., request variance of Chapter 62, Article 9, Brevard County Code, Section 62-3316B4, to permit a variance of 8 feet from the 15-foot front perimeter setback for a sign and a BU-2 retail warehousing and wholesale commercial zoning classification located in District 2. And the third one would be Mike Erdman Motors, Inc., request variance of Chapter 62, Article 9, Brevard County Code, Section 62-3316B4, to permit a variance of 8 feet from the 15-foot front perimeter setback for a sign in a BU-2 retail warehousing and wholesale commercial zoning classification in District 2.
Thank you. Would the applicants please come forward? So could you state your name and address for the record, please?
Yes, my name is Cliff Repperger. My business address is 2101 Waverly Place, Suite 100. I'm an attorney with the law firm of Whitebird, and we represent the applicants Geraldine Watson and Mike Erdman Motors by way of a authorization to represent for Plumosa Investment Partners, LLC. And with me today, I have
Okay.
Plumosa Investment Partners Principal Mark Hudgens as well.
Okay. I know you're an officer of the court, but for consistency of our procedures, I'd like to swear you in. Do you swear that you are going to give us the truth in your testimony today?
I do.
It's been a long day.
Thank you. I do have something to pass out. It's an aerial photo just to give you all orientation. I know that you have that in your package. I think
Just make sure.
I think it's in the GIS map tab of your pack, but if you want to have a copy of it, just look at it.
If it's,
If anybody.
is it this?
It was the aerial, just to kind of orient yourself, because
We have it.
Great.
We
Okay,
have
perfect. So you covered the procedural issue here with regard to the fact that this variance, we're asking for the same variance on items 6, 7, and 8 today, so it's all the same variance. The variance is what's being requested is part of one comprehensive multi-parcel redeveloped commercial center project for these sites and these particular parcels. There's a site plan, a conceptual site plan in the package under the survey tab in your package that's dated October 14th, 2022. I think that's referenced in the staff report. If you look at that site plan, you'll see that the overall concept plan. When we initially submitted this application for variance, or these applications for variance, it also included a variance request for the parcel that's reflected as the Wawa as well, which is the farthest western parcel. That's part of the project, but not requiring a variance, as I'll explain in a minute. They're also going to have a sign that's going to be on the 520 right-of-way. When we filed the applications, we came to find out that there is an existing variance already from 1969 on that parcel. It's V-0234, and that variance is actually for a variance that is greater than what we were asking for. That was for 12 feet and 12.5 feet. Although it's unclear to me exactly how the orientation of that is, that's what's listed in the variance. We've confirmed with staff that for our purposes, we can utilize that variance for that parcel. So we're only asking for 3 on the parcels to the east, as reflected on the site plan. So what we're asking for, again, is 8 feet of a required, from 8-foot variance from the required 15-foot front setback for freestanding signs on these parcels located immediately south of 520, and we are east of Plumosa. That's the orientation. If you notice, and the reason why I had raised the aerial with you and why I wanted you to look at that is the parcels here are unique in that there's a substantial landscape buffer between the actual 520 right-of-way corridor and these parcels. It's approximately 35 feet in width with the sidewalk. It includes, and it's part of the actual right-of-way, but it's a landscape buffer that is between the actual parcel northern boundaries and the actual pavement. What you can't see on this aerial, and I don't know if you have any aerials in your package that illustrate this, but, and I know this is in D2, so you probably looked at this, but as you go west on 520, it's about a block or so to the west of Plumosa. This landscape buffer that you see no longer exists on those parcels as you move westbound. So the parcels as you go west past Plumosa actually sit, those parcel boundaries, the northern lines, sit much closer to the 520 right-of-way than these parcels do. That's significant because those parcels actually have signage that's closer to the right-of-way than we would be. And that's part of the justification and the reason for asking for the variance today is because we're so far already from the improved right-of-way that for visibility purposes and signage, in order to get the same level of visibility that those parcels to the west have, we need this variance to be a little bit closer. And because of the buffer, the landscape buffer, any adverse effects related to that location are kind of mitigated by the fact that the parcels are already set back so far to the south, given the landscape buffer. So just walking you through the criteria, and I know you've done this with some other applicants, so I'll kind of just help you from our standpoint of what we're asking for. We do need to meet the criteria for purposes of a variance under 62-253A of the code. There are 6 criteria for the variance. The first criteria is that the special conditions and circumstances exist, which are not applicable to other lands, structures, or buildings in the applicable zoning classification. Our response to that is that the State Road 520 roadway is very unique within the county as it's been widened. It's a 6-lane road throughout.
I'm sorry, sir. Can I interrupt you for just a second? We have those, and we have those in writing. You're reading them over as what we already have in the record.
If you don't want me to explain to you our justification for the variance, then that's fine. I'll be more than happy to let the chair.
We already have that. We've already read them over.
Right.
And I'm just trying to keep it as short as possible.
With that being said, if you have any questions for us, we'd be more than happy to answer them for you. Other than that, we would respectfully request that you grant the requested variances.
And just so you know, this comes up quite often, and so we have to do this quite often, is let people know we've already got that, and there's no reason to read it in.
Understood.
Okay, so I just didn't want you to think I was being objectionable to you.
And I don't. Oh, and I'm going to stay. You got it.
Your application arises in, wait a minute.
District 2.
Yes, District 2, Mr. McCann. It's been a long day.
I had to look at the clock to see if we were going to say good evening or good afternoon. So good afternoon. Did I hear you say you're bringing a Wawa to Merritt Island?
That's correct.
You could have stopped there. Motion to approve. I'm just kidding.
You love their sandwiches.
They do have good sandwiches.
No, the only comment I want to make, and I think you addressed it, is you have that 35-foot landscape buffer from Route 520 to your property line. And then from the property line, you're going to have an extra 7 feet to where you're going to build the sign. So you're 42 feet away from 520, right?
That's correct.
All right, no more questions.
Any other questions? Yeah, I'll bring something up during our discussion, but you can, let me turn around and look, but I'll ask officially, is there anyone here who wants to speak in favor or opposition to this application? Seeing none, any final? The gallery's empty if people.
No further comment.
Okay. Very good. So at this point, we need a.
So I'd like to make a motion for the first item, which is labeled H6 for variance 22 Victor 0043. I make a motion to approve that variance as depicted on the survey.
I'll second that.
Okay. Any motion's been made to approve by Mr. McCann, seconded by Mr. Rhodes. Is there any further discussion?
Nope.
The only thing I was going to say is that we just approved a month or two ago something very similar to this on the opposite side of the road in that area.
We did.
Where they had a large setback signage,
Yep, we
same
did.
thing.
Exactly.
So with that said, of course, I'm in favor of continuing my precedence. Anything else? You stole my thunder. I'm supposed to read these. I'm going to read this once and ask that it be applied to the other two applications once we get there. That special conditions and circumstances exist which are not applicable to other land, structures, or buildings in the applicable zoning classification, and I would say that broad frontage within the right-of-way is a special circumstance that is in favor of this application. That special conditions and circumstances do not result from the absence of the applicant. No, DOT did that. That granting the variance requested will not confer on the applicant a special privilege, and I'm sure you're fine people, but I don't know about elected office and celebrity, so I don't think that would sway our decision here. That literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter, and would constitute unnecessary and undue hardship on the applicant. I think literal enforcement would be inappropriate here, would deny you rights that are applicable to other properties within the zoning. That the variance granted is the minimum variance, yes, it is, especially considering the broad frontage. That the granting of and actually it's less than a previous variance for similar circumstances, I guess on these properties or adjacent to them. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and I believe that we all find that this will not be injurious or detrimental to the public welfare, seeing as you're so far off the traveled highway. So, having read those 6 in, because of the similarity of this application and the other 2 that follow, I'm not going to reread them at that time. However, at this point, I will call a vote on H6, which is the application before us. All in favor, say aye.
Aye.
Any opposed? That particular one passes 4-0. Having had previous discussion, very similar to the same application, and having read in the 6 hardship questions, I'm going to call the vote on.
Can I make a motion?
Oh, okay.
I make a motion to approve the variance request as depicted on the survey for item H7, which is variance request 22 Victor 00044.
I'll second.
Okay. Motion's been made by Mr. McCann, seconded by Ms. Partridge. All in favor say aye.
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 Any opposed? All right. I need a motion on number HH.
I make a motion to approve the variance request as depicted on the survey for item H8, which is variance request 22 Victor 00045.
Okay. A second?
Second.
Okay. Motion made by Mr. McCann, seconded by Ms. Partridge to approve the variances depicted in the application on the survey. For this one, call the vote. All in favor say aye.
Aye.
Any opposed? Okay. My final duty today is to declare this meeting of the December 2022 Board of Zoning Adjustment adjourned.
Chair, do you mind if I make a quick comment?
Go ahead. We've already, no, go ahead.
Thanks. It could be post-meeting. It doesn't have to be on the record. I just want to say the last year and a half I've served on this board, and I've not one time outside of the board meetings ever spoke to any of the staff members. I think it's appropriate to say that I want to acknowledge your hard work. You put together some fantastic packages, you answer our questions, you give us great guidance, and you make our lives much, much easier. So I want to thank you, and I think I'm speaking on behalf of the other board members for what you do, and we really appreciate what you do, and I want to wish you a happy holidays.
Absolutely.
Very good.
Thank you.
Thank you.
And again,
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.